The slogan for our organization is now more than ever. And the reason we chose that is that international law is relevant to our everyday lives now more than ever.
I joined the American branch 30 years ago when I was working as an attorney advisor at the US Department of State. All of my colleagues said it was a terrific organization and a place where I could begin my networking. And it has paid off over all those years.
Nothing is more important in today's global world than an understanding of how international law can help address our collective needs as a human society.
By bringing together nationally and internationally recognized experts, ILW has provided an opportunity for the education of practitioners, scholars, and students, and it also provides a forum for the exchange of ideas and the development of international law.
It's difficult to identify a single panel that is memorable to me because the fact is they're all unique, they're all memorable.
ABILA has just been a really incredible resource in being able to connect me with other practitioners, but also other academics. In one area of law where I practice before the International Court of Justice,
over the years, I've developed not only colleagues who share my passion for international law and the law of the sea, but friends and folks I've worked with as co-authors on other projects.
The American branch is so relevant today because it's successfully bridging the gap between the profession and future generations of lawyers.
I'm incredibly proud of ABILA's 100-year legacy of doing that work through its conferences and its events and its committees. And I'm incredibly proud that that work continues to this day.
Not only is the world more connected today than ever before, but the challenges that it's facing require global cooperation, whether it's climate change, a global pandemic, protracted armed conflicts, or rising nationalism. ABILA provides a forum to address these challenges through education, research, and events.
Good morning, good afternoon, good evening. Welcome everybody to ILW 2021. It is thrilling to see you all here, colleagues, friends, students, international luminaries, judges, practitioners, and friends of international law. We are thrilled that you all took time yourselves to invest in international law, as the theme for this year's weekend is reinvesting in international law. I am so sorry that we can't be together in person, but you should know that there are over 1,500 registrations for this conference and that individuals are zooming in from more than 70 different countries, which is something we could never have achieved if we were gathering in person as we usually do at Fordham University in New York City. We will have 32 panels over the next 3 days, 19 of which will offer continuing legal education credit. We have 25 sponsors, including thank you to our diamond level sponsors, Arbitration Place, White & Case, and Debevoise and Plimpton. I'd like to thank so many people that have literally been working for the last 11 months to make sure that this weekend happens and happens well. Our team at Arbitration Place, particularly Heather, Kira, and Jeffrey. Our ILW co-chairs, Nawi Ukabyala, Amity Boy, and Julian Arado. The entire International Law Weekend Organizing Committee, And Madeline George, our ILW Administrative Officer and our Membership Officer, Ruxar Azame, our Media Officer, and our 8 student ambassadors from Case Western University School of Law, Georgetown Law School, George Washington Law School, Pepperdine, Santa Clara, Touro College, UIC John Marshall College of Law, and Willamette Law School. And Heather, if you wouldn't mind just sharing the screen, you'll see us all with our official ILW 2021 t-shirts. And there we go. At least some of our members of our organizing committee, you can see them there. They have literally been working for 11 months to make this weekend happen. And you'll notice as well, our president-elect, Michael Scharf, who will take over next year from me, and David Stewart, the chairman of our board. Thank you, Heather. You can unspotlight our organizing committee. I'd also like to thank all of our committee chairs for hosting networking rooms, because ILA is part of a 63 branch organization, and we do a lot of our work on international law through our committees. And I'd like to thank the committee chairs for hosting the rooms, as well as our directors of studies, Jennifer Trahan and Peter Yu, for organizing that. Spot Video for the lovely video that we began with, and it had a little glitch at the beginning, but it's actually posted to the landing page for the conference. So if you have a problem, you can see it there. And I'd particularly also like to recognize the South African branch of the International Law Association. We've partnered with them. Some of their members are attending our conference, and we hope to have that as a special continuing relationship. And in fact, one of our plenary speakers, Dire Talati, who you will hear from today, of course, is the president of the South African branch. Following today's plenary, which I'll introduce in a moment, we will have 4 excellent panels you can attend. And our program concludes with networking sessions by many of our ABILA committees: customary international law, arbitration, international criminal court, intellectual property, Islamic law and society, legitimacy and fundamental principles of international law, and teaching public international law. Tomorrow we'll have a keynote address by Professor Ona Hathaway, also a counselor to the dean at Yale Law School. We'll have many, many panels, 16, I think, tomorrow, 12 networking rooms in the afternoon and evening. And don't forget, especially for our student attendees, tomorrow is our 2nd annual International Law Trivia Night. Gather some friends or invite fellow attendees at tomorrow's networking sessions to play on a team together. And I hear from the organizers that if you already have your team organized, you can submit your information in the program, and that gives you access to an exclusive hint. Finally, on Saturday, we'll conclude with a keynote address from former Chief Prosecutor of the International Criminal Court, Fatou Bensouda, who will also receive our Outstanding Achievement Award, our 99th annual members meeting, 12 more panels, and a special career program that Amity Boy, one of our vice presidents, coordinated with the International Law Students Association. We have a help desk if anybody's having difficulty with the Zoom, and CLE credit is provided for the 19 panels offered to all ILW attendees at no additional cost through the generous sponsorship and assistance of White & Case LLP, an accredited provider of New York and California CLE credit. Now, without further ado, thanks all of you for coming, and I would like to introduce today's opening presidential plenary panel. We have 4 extraordinarily distinguished participants who have agreed to lend us their time and talent, and I'll invite them to turn their cameras on so that I can introduce them and begin the opening program. Thank you. And for all of those in the audience, you can pose questions to our panelists in the Q&A. You won't be able, other people won't be able to see it, but you will be able to see it. And there is also a chat function that is enabled, I believe, for you to converse with your fellow attendees. So we have 4 distinguished panelists representing 4 different, if you like, sectors or positions in international law. We have Pablo Arrocha, who, did I say that right? Pablo Olambuenaga, who is the legal advisor to Mexico's mission to the United Nations. He's also a distinguished author. You can find many of his publications on just security. We have Ambassador Nazat Shamin Khan, who's the current president of the Human Rights Council, and herself a distinguished practitioner of international law, who served as Fiji's permanent representative to Geneva. We have Diri Tladi, a professor of international law and current member of the International Law Commission from South Africa, and Nicola Bonucci, who I know from another project where we co-authored a Jessup problem together in a former life, who is the former legal director of the OECD and is now a partner at Paul Hastings. And I'm abbreviating their extraordinary biographies because I don't want to spend too much time on introductions. We're going to begin our program with President Khan, because unfortunately she will have to leave our gathering a little bit early. Each one of our speakers will give us 5 to 10, hopefully, minutes of their thoughts about what it means to be reinvesting in international law from their perspective, their vantage point. They come from different regions of the world and different areas of international law practice. And followed by that, they'll have an opportunity to comment on each other's remarks. And meanwhile, you, our wonderful audience, please do put questions in the chat, and I will, the panelists can see your questions and either respond during their initial remarks, their following remarks, or we'll take up questions at the end of their presentations. So President Khan, I turn the virtual podium over to you to kick us off.
Thank you so much, Leila. It's such a pleasure to be here. And in the traditional greeting of Fiji, Bula Vinaka. Welcome to you all, and I'm very, very pleased to be participating in this panel today. As you've heard, I am the ambassador of Fiji to the United Nations in Geneva, and this year I am serving as the president of the Human Rights Council. And I am particularly pleased because of the topic of this opening plenary, that is reinvesting in international law, because I am a great believer in multilateralism, and I believe that it's international law and international legal policy that really shapes the conversations around multilateralism. In particular, it guides the negotiations on a number of very important resolutions, and I think that international law has shaped the way international conversation has led to significant change internationally. So I'm a great supporter of multilateralism, but I also believe that international law really grounds us and helps us to ensure that the progress we make as a global community is in fact grounded on legal concepts, on sound analysis, and on a consciousness that the law and social justice must match in this journey that we all take together. My experiences in the Human Rights Council has really reinforced this belief. And I do think the conversation has changed in the Human Rights Council. I think it's changed for a number of reasons. One of them is that we all see the importance of an institution where changes can be made, and that they can be made with the cooperation of countries which are both developed and developing, small and large, and with different sorts of human rights journeys. So the Human Rights Council really celebrates diversity of views. And I think it's really important that it is this diversity which must be preserved. I do not think that there is one politically correct way of seeing the world. If human beings around the world think differently on matters to do with social justice and human rights, then there's really no reason why countries on the Council should think in an identical way. So let me talk about a few examples of common problems which have been faced by institutions like the Human Rights Council, and how time and developments in international law have really shaped those conversations and responses to those common problems. And I think at the top of the list must be climate change. When Fiji first opened its mission in 2014, and started to sit regularly in the Human Rights Council, we heard very little about climate change. In fact, it was a very strong view, still expressed, but a stronger view then, that it was not the business of the Council to talk about environmental law or environmental concerns, that anything to do with the environment belonged to another institution, either UNEP or UNFCCC, and really there was no connection between human rights, the law, and the environment. We've come a long way since then. And now increasingly, countries are recognizing the important role of human rights everywhere. And this common strand of human rights law and international law, I think, really does help us to ground the conversation and emphasize the need for conversations like human rights and climate change to be held in institutions like the Human Rights Council. So very important that we recognize that there has been a fluidity about the nature of the conversations that are held in institutions like the Human Rights Council. Secondly, in relation to multilateralism, we are hearing louder and more often the voices of small states. And I believe it is the voices of small states which have changed the conversation on a number of issues. If we do not want the conversation to be dominated by the concerns of large and powerful states, then it's very important that small states be at the table, and in addition to that, that they integrate their concerns on both international legal issues as well as human rights issues in every institution where they are represented. But we have to remember that in a place like Geneva, it's not very easy for small states to be present, and to be present in a qualitatively effective way, because it's very expensive to open a mission in Geneva. But many countries, small countries, think that if you're going to prioritize your international foreign affairs agenda, you're going to really focus on trade or peace and security in the United Nations in New York. Human rights, international human rights law do not come at the top of the list of those priorities unless there is something in that conversation for small countries. So I think examples like environmental law and human rights itself as a concept have really persuaded small countries with a focus on climate change and human rights to see the value of multilateralism at every level. The other important thing about multilateralism is that small states which want a voice really need to have the mechanisms to encourage the expression of opinion. First of all, as I've said, we're not always there. We small countries are not always at the table. Secondly, we don't always have the resources. And thirdly, the subjects which are on the agenda may not be terribly interesting to a small island country, for instance, with a lot of hurricanes and disasters, and a very strong focus, for instance, on fish, on nuclear testing in the Pacific. So how do you transform your ability to be present at meetings into a qualitative change about the subjects that are actually discovered and discussed at an international institution is a challenge for multilateralism. Let me say this, that the importance of multilateralism depends not just on what is discussed, it also depends on how it's discussed. And that's why process is as important as substance if we are to give multilateralism the kind of platform that it deserves, because multilateralism is an equalizer. If we're to be sure that the conversation is not going to be dominated by issues which are driven by a few states, then we do need to have an equal access to international institutions, to law, concepts of law, and as well as to the ability to drive the agenda. Let me give you an example of how the law has not always kept up with the needs of small states. In the Pacific, as you know, the sea levels are rising. And with rising sea levels come important legal questions about what is going to happen with cross-border displacement if the sovereignty of individual countries disappears. We look to the refugee law, to the law on asylum, we look to the law of the sea, and actually there are no answers. in order to ensure that international law institutions and multilateralism has meaning to the priorities of small countries, we must encourage multilateralism and the ability of small countries to have a voice everywhere. And in this, the language of human rights is absolutely central. We do not want a group of scientists and very hardened lawyers to sit around a table and decide for the rest of the world what is going to happen if Nauru, Kiribati, Tuvalu disappear under the waves. In addition to this conversation, which is so important to small countries, is about the intersectionality of human rights. The relationship between civil and political rights and economic, social, and cultural rights really means something to small countries, because this intersectionality unfolds itself before our eyes, particularly in the event of disaster or climate change. And climate change really does see intersectionality. So then how do we change the conversation? How do small countries use multilateralism to ensure that the conversation is about a matter which is relevant to them? How do you speak to the law of the sea to really define the issues of diminishing coastlines and the size of the EEZ and the issue of state sovereignty when a country no longer exists? In the Human Rights Council, as I said, we never really discussed climate change until the Maldives became a member of the council, and in 2008 introduced for the first time a resolution on human rights and climate change at the 7th session of the council. And as you are probably all aware, in this very last session, the 48th session, with much stronger representation from small states, countries like the Marshall Islands, Bahamas, Mauritius, and Fiji, we now see a successfully concluded and adopted resolution entitled Mandate of the Special Rapporteur on the Promotion and Protection of Human Rights in the Context of Climate Change, which created a special rapporteur for the first time looking at the negative impacts of climate change. And secondly, another true multilateral effort led by small countries, in particular, the Marshall Islands, Bahamas, together with the European Union, because partnerships are important, Panama, Paraguay, and Sudan, a resolution which recognizes the right to a safe, healthy, and sustainable environment. Enormous progress. For those cynics who believe multilateralism does not work, please come to the Human Rights Council and see the fluidity of the discussions. See how the opinions change in that room about issues like SOGI, for instance, about issues like access to reproductive rights for women and girls. We have seen so much change, and in one area, particularly in the area of the relationship between human rights, the environment, and climate change. But before I stop, and I'm sorry, I know that I'm speaking for too long, but before I stop, may I also say this? I'm often asked, what about polarization and politicization of institutions like the Human Rights Council? What about having states who don't really believe in human rights? And my answer to that is this: we must celebrate diversity in the Council. In order to ensure that this conversation moves forward, it's important to have everybody in the room with a diversity of opinions that they might hold on the most fundamental of issues in relation to both international law and human rights. However, in order to ensure that this is truly an inclusive conversation, and you are hearing the voices of small countries, you really have to adopt mechanisms to encourage the participation of the small actors. So for instance, in the Human Rights Council, we have the Voluntary Technical Assistance Trust Fund, which supports the participation of least developed countries and small island developing states in the work of the Council. At the recently concluded 48th session of the Council, the Trust Fund supported 16 delegates. So what happens? They come to Geneva. Many of them do not have missions. They attend the sessions. They become extremely knowledgeable about the Council because they participate actively. They deliver interventions. They analyze the way that the arguments are proceeding. And when they go back home, they build the capacity of their countries for equal and active participation in institutions like the Human Rights Council. So this one mechanism has done so much good around the world to ensure that a conversation at the Council is truly inclusive. And it's very important that we continue to really celebrate such mechanisms and really do help them to grow so that we get more people on the table than countries which have a completely different agenda, for instance, for the majority of countries around the world. In addition to that, it's very important to bridge the divide between New York and Geneva. New York has always been a place where you have a conversation about peace and security and development. And human rights is a bit of a second-class citizen. But actually, if you are to ensure that you celebrate the prevention agenda of the United Nations, then you've got to accept that human rights violations are an early warning system of conflicts and the deterioration of peace and security that's going to happen down the lane if you're not careful and you don't nip human rights violations in the bud. And so therefore, so important for New York and Geneva to work together in collaboration. So important that we don't work in silos. One very, very important issue which does lead to gaps in the system is when the different UN institutions have no idea what's happening in other institutions. And duplicity of work undermines the effectiveness of the United Nations. So this week I have been in New York, and I'm delighted to be in New York. And one of the reasons why I'm here is to really help to bridge this New York-Geneva gap so we see the relationship better between human rights, peace, security, and development. So thank you. Apologies, Leila, for taking up so much time. I'm honored and privileged to be here, and I look forward to hearing from my colleagues on the panel. Over to you.
Thank you so much. That was just fantastic. And you're a wonderful ambassador for Fiji and all small island nations. And you raised the really important issue of you need to have a seat at the table in order to be able to influence policy. And Shirley Chisholm from my country has a wonderful quote that says, if they don't give you a seat at the table, just bring your own chair. And so that's something that's really important to think about as well. And that's the case of civil society organizations often have to bring their own chairs. So now we're going to go to somebody else who's working in New York, who's been a diplomat for his country, I think for 15 years, as well as a professor of public international law. And that's the legal advisor to the Mexican mission in New York, Pablo Arocha Olabuenaga. So Pablo, over to you.
Thank you very much, Leila, and good afternoon to everyone. It's truly an honor to be here, and especially with such a distinguished panel. I feel also that we're in family. I'm a member of the Mexican branch of the International Law Association. It's really a pleasure to be again participating in the ILW, and I wanna share a little bit of the things that we do and think and perceive from here, having this privileged seat of being a legal advisor to a mission in New York from a country like Mexico on what are some of the topics that where we can really make a difference in reinvesting in international law. And I think that many of the things that I'm going to say now bode very well with what we have just heard from President Khan, who, by the way, as a commercial and parenthesis, I would like to mention that Mexico now, that, as you know, is a member of the Security Council, will be taking over the presidency of the Security Council this next month of November, so pretty much next week. And we will be organizing 3 signature events, but 2 of them are one related to improving the coordination and collaboration amongst the main UN bodies, precisely to find these linkages between development, human rights, and security as one package. And another one that will be actually presided over by the President of Mexico, Andrés Manuel López Obrador, who will be coming to New York precisely to tackle inequalities and poverty as drivers for conflict. So hopefully this is also a contribution to those topics. But in the time that I have, I wanted to touch upon 3 examples of areas where I think we can really invest in international law and things that, as I mentioned before, we see from here, from New York, and particularly from this office. So the first one has to do with the relationship between the International Law Commission and the General Assembly and the 6th Committee. And I'm very happy also to be here with my good friend Dire, who is an ILC member, and we've had many conversations on this, and it will be great to now extend and continue that conversation in this panel. But as you know, the ILC basically has the mandate of codification and progressive development of international law, which at the end of the day happens through the action of states, because all of the products of the ILC come here to New York, to the General Assembly, in particular to the Sixth Committee, where action should be taken based on those products. However, since 2001, we have now 10 products, in particular 10 draft articles that have been concluded by the ILC successfully, which have just been lost in a cyclical vortex of inaction in the end of the Sixth Committee. And this has had many consequences. One of them has been that the ILC itself has had to reassess the type of topics that it picks up. By the way, it also now has a panel on sea level rise, which I think is crucial. But also it has then started to shift its approach and work on products that are other than our draft articles, like guidelines or conclusions. And Dire is also a special rapporteur, and he can speak to that. The irony here, to me, is that in that same period of time, from 2001 till now, it doesn't mean that there has not been codification processes going on here in New York. There have been many. We've adopted the Arms Trade Treaty, the Treaty on the Prohibition of Nuclear Weapons. We are currently negotiating an implementing agreement of UNCLOS on what we call BBNJ, biodiversity beyond national jurisdiction, which again puts a focus on issues that President Khan mentioned, like nuclear testing and fish. So the question then is, why do we have codification, but not from the products that come from the ILC? And so I think this is a moment where we should need to reflect more on how to reinvest in international law by strengthening this relationship. And right now we're in a crucial moment when the Sixth Committee, we're negotiating as of now, the possibility to move forward on a negotiation on crimes against humanity based on draft articles that were adopted by the ILC. And if we manage to get something moving there, that will be a huge breakthrough on two fronts. First, it would change the dynamic of the relationship between the ILC and the Sixth Committee. And of course, second, it would fill a gap in international law with respect to that crucial topic. So that's my first point. The second is basically what President Khan has mentioned, the need to hear all the voices to shape international law. And the one example I would add to what we have already heard has to do with use of force, for example. Aside from treaty-making processes, what we do and say in these deliberative bodies of the UN is also important, because it does shape international law, because it also positions our opinion juris. And that is the reason why Mexico has brought a proposal to analyze the application of Article 2.4 and 51 of the Charter of the United Nations, formally submitted to a subsidiary body of the General Assembly called the Special Committee on the Charter of the United Nations Organization and on the Strengthening of the Rule of Law. Again, here, my friend Dire has written quite a bit on this, but our proposal responds to the opacity in which Article 51, which, as you know, talks about self-defense, about the way in which this article has been invoked in recent years, especially regarding the use of force against non-state actors in a third country without its consent, under a so-called doctrine of unable and unwilling. And this for us is very dangerous and grave. It's an issue that creates fractures to the collective security system established in the Charter. And our concern has been that, as it was mentioned before, this is a conversation that needs to be had amongst all the member states, the 193 United Nations member states, because this is a matter that is of importance for all of us. And that is why we want to have an open and transparent conversation about this, not just limited to the very few states that engage in this type of practice, that claim, therefore, that the existing rules have changed, the interpretation of the rules have changed. And I think collectively, we, all member states, also have the responsibility to spot these dangers in these types of assertions and to open up these conversations and engage in these conversations. So again, we can reinvest in international law. And to conclude, as a third point of reflection, I would focus very briefly on the need to reflect on our counterterrorism strategy after the 20 years that we've had, mainly since 9/11, and the way in which we at the United Nations have responded to this. In my view, this issue really requires some more detailed attention. In this time span of 20 years, a lot has happened in this front. We created at the UN, the Security Council created the Counterterrorism Committee, supported by a special political mission, which is the Counterterrorism Executive Directorate. It also established a sanctions committee, the 1267 Sanctions Committee for Al-Qaeda. More recently, we have established the Office to Counterterrorism as an Undersecretary General position within the UN architecture. So all of this has evolved from a political point of view and mostly from the Security Council. But on the other hand, the negotiation towards a comprehensive convention on international terrorism have been in an impasse throughout these same 20 years or more even, which basically means that we have been betting more and pushing more a so-called legislative process by the Security Council with a focus on politics rather than on legal considerations, which has proved to be very challenging and to create lots of issues when it comes to terrorism, and in particular in the front of human rights, for example. And Mexico, for many years, has been the country that has brought the issue of the need to respect and protect human rights in the context of the Third Committee in the General Assembly, with a resolution that is adopted there. But gray areas continue to appear, basically because we don't have a legally agreed definition of terrorism as of today. These gray areas expand now with new terms, because again, we don't have a defined legal term of something like violent extremism, which now we've incorporated to our narrative. When it comes to the sanctions approach, like it has been the case of 1267, with the recent developments in Afghanistan, we now see that we're in a situation in which 21 sanctioned individuals who are in the sanction list of the Security Council are now members of a government. And there's a challenge there on what to do with this reality and to reassess if indeed this strategy of how to tackle these issues is working in the way we should expect it to work or not. And so for all these reasons, I believe that we should take this 20-year mark as an opportunity to reevaluate and reassess our strategy to address the challenges posed by terrorism, and to recognize that this problem will not be solved through the use of force, despite the narrative of wanting to call it a war on terror, but that we have to go back to basics, to adopt a preventive agenda, to focus on the root causes of terrorism, and again, to reinvest in international law so that we can get back on track. So with these very few remarks, I'll stop, because I know there's a lot of information there, and I'm very much looking forward to our conversation. Thank you very much, Leila.
Thank you so much, Pablo. That was really fantastic. And it does tie in very nicely both to, I think, President Khan's remarks, and also now we'll turn to Nicola Bonucci, who of course was with the OECD for nearly 2 decades, I think, before becoming its legal director, and has focused a lot on corruption and transnational crime, which is related, of course, to terrorism. So Nicola, go ahead and tell us, how do you see this issue of investing or reinvesting in international law from where you stand?
Thank you very much, Laila. And as Pablo and the ambassador, I would like first to thank the organizer, and you in particular, for inviting me to share my white hair and my age, because I'm pretty sure I'm the older one in the panel. And you know, you said 20 years. In fact, it was 26 years at the OECD and 5 years at the Food and Agriculture Organization, so more than 30 years. But what is interesting is that I've learned a lot also in my last 2 years in the private practice, and what I'm going to say is also a bit maybe a slight change of perspective or a new perspective. So let me start with a basic idea. I think in order to reinvest international law, we need to reinvent it. And I would like to start with some old memories. When I finished my studies, the hot topic was the Montego Bay Convention, the Law of the Sea Convention, which I think is, in a sense, almost the typical example of the international law that I studied in the end of the 70s, beginning of the 80s. And I think this is an international law which, for whatever reasons, is not fit for purpose anymore. I'm going maybe to make some provocative remarks, but I think it's also useful. And one of the advantages of not being an international civil servant anymore is that I can pretty much say what I think, and I will take advantage of that. So what have happened is that I think we have to acknowledge that there are new actors, that there are new ways of developing international law, and that there are new areas. So the new actors. The international law I study was very simple. You had states and international organizations. But even that, there was some discussion. But let's acknowledge that there were an acknowledgement of international organizations. This was the word of the 80s. Today, states do not control international negotiation anymore. There are private actors, private sector, civil society organizations who are very much involved in the negotiations at all levels, both national and international level. In addition, there is a new actor in town, which is the public opinion. To be very honest, in the 80s, in the 70s, until the mid-90s, international negotiations were not really taking into account what public opinion was thinking about what was going on in Vienna, Geneva, or Paris. Now, in public opinion counts. And public opinion, in particular in Western countries, is increasingly disenchanted with public international law and cautious, if not suspicious, of any form of delegated sovereignty. You can see it also at the level of national parliaments, who are more and more, I would say, anxious of whatever is decided, discussed in Geneva, again, New York, or somewhere else. We had the example of the chart on migration, for example, and the reaction in some national parliaments. The second point is that the United Nations, and here I will be hated by a number of you, but the United Nations-based model, which was based on the fact that you had a political organization based in New York, and then you had the sector organizations, and the ambassador referred to that, dealing with the Food and Agriculture Organization, the WHO. This construction, which I think was a way to decouple political and technical issues, and was a response to World War, doesn't really stand the test of time anymore, because technical issues are political. And because there are no technical issues which can be seen by one single organization, and the ambassador referred to it. Climate change is not only about environment. The financial crisis was not only about the banking sector. And clearly, COVID pandemic is not only a health issue. So, the whole system has to really reinvent itself. And third, even international organization, and I'm still a true believer in international organization in the sense of intergovernmental organization, but let's face it, let's recognize it. There are new groups like the G7, the G20. There are new non-intergovernmental international fora like ICANN, the international fora which deals with the internet. There are standard setting bodies like the International Standard Organization who are playing an increasing role. New method of work. Again, when I was a student, it was very simple. You had the sources of international law. And then, there were some discussion about these strange things called the recommendation that someone started to call the soft law. The soft law is pretty much the flavor of the day today, much more than what we used to call the hard law. And the soft law is developed in different ways. As I said, or the hard law is developed in this different way. As I said, non-governmental organization, private sector, participate in the international negotiations. The provisional texts are shared. And I will say something which is, this one, I think, I hope there is no media in the room. There is a lot of focus on transparency, but there has been a little attention of what it means in terms of the dynamic of international negotiation. You know, the techniques that were used in the 80s and the 90s, including in the Montego Bay Convention about nothing is agreed until everything is agreed, it's much more difficult to carry out when all the provisional texts are out in the open and everybody knows that they will be out in the open. So basically, the countries or the negotiator tend to put everything on the table and to start with very radicalized positions. The transparency has changed the dynamic of international negotiations. I'm not sure that international negotiators have fully grasped with that. And the length of the negotiation. I talked about the Montego Bay Convention, 10 years on negotiation. 10 years was already a long time in the 80s, but in 2022 is an eternity, an eternity. New areas of work, and I will be very quick on that because I think, you know, the ambassador mentioned it already. The world is changing so rapidly. Areas like internet, artificial intelligence are not really covered by international law. New areas of work develop new technologies, and areas like privacy and data protection are dealt much more at the national level than at an international level. And even in international economic law, we all see the situation of an organization like WTO. So how do we reinvent international law? And here I will not reinvent myself, so I will piggyback on a speech that the Secretary General of the OECD delivered a few years ago in the context of the UK Global Summit, which I have to say I crafted. So I don't think I'm taking any ownership out of him. And we put together some ideas. The first 3 ideas. The new international law should be more adaptable and inclusive. It should be able to try to address one issue for a set amount of time, not necessarily trying to be there forever. You know, we should look at what is used in other areas of law or in other areas of regulation. For example, have you heard the sandbox approach? Do you know what the sandbox approach? The sandbox approach is an area it's used in the fintech world. The regulators provide the startups the possibility to innovate in a controlled environment under the supervision of the regulator. So there is an idea, okay, try and error. I think we need to do more try and error in the international arena because the issues are complicated and we may not get a perfect answer. We need also to be more effective and innovative. As I said, for me, the discussion about hard law and soft law at the end of the day is less important than is it this effective. Pablo referred to the opinion juris. I think the opinion juris is really the mantra of the 21st century. Do countries feel compelled, feel obliged, whatever the form of the instrument, the name of the instrument is? And third, I think we should be much more accountable. A lot of focus has been put on transparency of the negotiations, transparency of the development of the international law. I'm worried that less focus has been put on the accountability. It's nice to be transparent in the development, but what is more important is the accountability, because it is with accountability that public opinion will effectively then get into believing again in international law, at least in the Western world. So all this is much easier to say than to do, and I fully agree. But I will finish by using one of the person I quote pretty much in every speech, which is Albert Einstein. What is fantastic with Einstein is that you can find quotes pretty much about everything, and they are so great. So Einstein said, imagination is more important than knowledge. Knowledge is limited, imagination encircles the world. So let's be imaginative.
Thank you so much, Nikolai. And I think you gave us a lot to think about there from your many years of distinguished accomplishments at the OECD, and before that at La FAO, and now in private practice. I don't know if we hate you. I think that was really just adding on to what the president said and what Pablo said, which is that there's a lot of work that needs to be done in our respective fields. So Professor Tladi, it is now your turn. And I hope I actually should tell our audience that we have Professor Tladi coming in from South Africa, where he is actually in Johannesburg, and I can see it's quite dark outside, I think. So thank you so much for staying up to be with us. And this is a truly global international law weekend experience. So Diri, over to you.
Thank you very much, Leila. I must also just say a word of appreciation for you in particular for initiating the coordination between the South African branch of the International Law Association and ABILA. And thank you again for inviting me for this panel. In the 4 years that I spent in New York from 2009 to 2012 as legal advisor of our mission, I was a constant participant at International Law Weekend. So it's nice to be back. And of course, it's also very nice to share the panel with such interesting speakers, such wonderful speakers. I must say, as I was listening to the talk, I thought maybe I should just say I agree with everyone and not say anything else. But I guess I should say something. So here we go. I guess my sense is that if we're going to ask the question about reinvesting in international law, we have to ask ourselves what kind of an international law it is that we want. In other words, we should ask ourselves why there is a need for reinvesting in international law. And I will say that the two publications have really inspired my thinking about the kind of international law that we want. It was in 1996. I had just competed in the Jessup in Washington. And while I was there, I picked up the late Thomas Frank's iconic book, Fairness in International Law and Institutions. And I must say, I was blown away. For me, that book gave a vision that approximates what international law should look like, an international law that is based on fairness and equality. Many, many years later, I had the occasion to read a book that was written at around about the same time by Bruno Zimmer in his famous Hague Academy lectures, From Bilateralism to Community Interest. And I think these two books really for me inspire, or at least the themes in these two books really for me inspire what international law might look like. So from a structural perspective, this notion of fairness as between subjects, but also from a more substantive content perspective, this notion of solidarity. I mean, I think these are the two things that I think are really important. Now, these books were written around about the Frank book was in 1995, Zimmer book is in 1994. So we're just over 25 years since. And I must say that we're no closer to nirvana, right? So the structure of international law remains decidedly unfair and unequal, at least as between the subjects, and the content of international law remains very far from solidarity. And a lot of the points that I'll make are actually very similar to what has already been said by the other panelists. So I start off just with the question of fairness and equality as between subjects of international law. We know, I think we all know, that international law and its framework for lawmaking remains decidedly skewed and unfair, right? There is certainly very little that can be done about some of the skewedness. So, for example, there is very little that we can do about the fact that the Security Council is composed the way it's composed, that certain members have particular privileges as far as decision-making is concerned because of the nature of the treaty instrument, which has almost sort of been endowed with this constitutional mystique and whose amendment is almost impossible. Yet even there, even when we're thinking about the Security Council, there are things that we can do. There are practical small things that we can do. For one thing, and here I might slightly disagree with some of the things that I've heard. Given the general undemocratic nature of the council, I think states and international lawyers that are interested in pursuing fairness should openly question what I call the usurpation of the council by powers that are not provided for in the council. So we see this expansion of mandate through its practice. We ought to question that. Instead, what we're seeing, and to be honest, we're seeing it from all quarters. It's not just from the powerful states, we're seeing it from all quarters. What we're seeing is a concerted effort by many different states and many different role players to, in fact, extend not only the depth, but the breadth of the powers of the Security Council. So we hear a lot, if something is important to me, I want it discussed in the Security Council. Climate change ought to be discussed in the Security Council. Now that might work for that particular issue, but the effect of that is essentially to expand the powers of the Security Council and is essentially to create, at least for the really important subject, a legislature which is undemocratic. The second thing that I think is within our powers to change, or at least is doable, I would ask this question. If people knew that the legal advisor of the United Nations has always come from Europe, always. There has never been a legal advisor from Asia, Latin America, or Africa. It's an unwritten rule, a practice which all secretary generals have abided by since the UN's inception. And surely this is something that ought to be challenged, right? I mean, this is not something that we accept, and yet we simply accept it. This is within the realm of possibilities for change. A final example I'll give is so we all know, right, and this has been discussed already on this panel, that international law is made by states. Of course, this is challenged. I mean, I think we can discuss that maybe if we have time in the round of discussions, but not all states participate equally. During a recent conference, as an example of sort of the unequal participation of states, I referred to the composition and representation in the International Court of Justice and International Law Commission. So I won't give that example, just in case anybody was at that conference. Instead, I'll give a different example, and this different example concerns equal participation at the table of decision-making, what Ambassador Khan referred to as a qualitative presence around the table. So I think generally, if I take the International Law Commission, which is a body that I know most about, states from the South generally do not provide written comments on the work of the International Law Commission. To give you an example, the topic that I'm responsible for, I have received 23 written comments from states, and only one comment was from Africa. There was one comment from Asia. There were 2 comments from Latin America. So you have 23 comments, or 23 states have commented, and only 4 have come from the South. And I can guarantee you, if you look at any topic of the International Law Commission in which inputs have been received, this pattern is probably repeated. And I think given the influence of the International Law Commission, at least I still think that the International Law Commission is hugely influential, it's imperative that there's equality in lawmaking. There are many ways, of course, in which this can be addressed. And again, perhaps if we have time in the question and answer session, this is something sort of that we can take up. But in the interest of time, I'll just move to the question of solidarity, and I'll do this really quickly, but I do think it's very important. In fact, this morning I was doing a keynote address for an ASA Institute conference on this. So this is almost a sort of a summary of this. So for me, solidarity concerns the content of the rules, right? So to what extent does the content of international law reflect solidarity? And by the way, it means a lot more than cooperation. I think solidarity appeals in a sense to sort of a sense of caring about one another. So how can international law reflect this idea that we all ought to care for one another? And here I'll only give one example, and that example is poverty. I won't bore you with statistics, but there's lots of statistics, and these statistics are really mind-blowing. They are staggering in terms of poverty and in terms of what's available. But if you think about the international community is very happy to sort of engage in very expansive interpretation to achieve particular value-laden positions in particular issues like international criminal law, international human rights law, and so on. But when it comes to poverty and the eradication of poverty, and say, for example, the possibility of interpreting the International Covenant on Economic and Social and Cultural Rights in a way that places the obligation on all states to eradicate poverty. Well, as soon as we come to this, suddenly fancy words like territoriality and sovereignty are suddenly remembered. The expansive anything is possible initiative that we see in international criminal law disappears, right? This I think is an indictment on the extent to which we are willing to really sort of endow international law with a proper appreciation of solidarity and sort of infuse this idea of solidarity into international. There are many other examples I could give. So Pablo mentioned the current negotiations on biodiversity. Here, the point I would make, Pablo, is how in those negotiations, which are also in a way about solidarity, the question of the common heritage of mankind is literally hanging on a lifeline and so on. So I'll just stop there, but thank you very much for your attention.
Thank you so much, Diri. Those were really, really thoughtful remarks. And I think they tie in nicely with Ambassador Khan's opening remarks. And I'm sorry that she had to leave early, but this idea that you had to link the civil and political to the social, economic, and cultural rights. And also to Pablo's idea about the Security Council, and maybe even to Nicola's idea about, is international law really fit for purpose if we have these kind of gaping holes in it? Why don't I give you each just a couple minutes to respond to anything that you've heard, whether it was from Ambassador Khan or the other panelists. And then we do have some questions. Thank you, audience members. We have about 7 questions in the chat, and you may wish to take up any one of them. I see a question on whether international law has evolved to something like transnational law. There's a question on the use of force that ties in directly to Pablo's intervention. So please, why don't each of you go ahead and respond. And Pablo, will start with you, and then Nicola, and then Diri, and then we'll revert to audience questions if we have time remaining.
Okay, so thank you. And very quickly, touching upon questions in the Q&A box. One about the disproportionate impact on the development of international law by big states. I think Diri also just touched upon this. The number of comments sent to the ILC is a key example. But I would say that yes, they do tend to have a push to have a disproportionate impact, arguing that a certain practice can be more valuable than others. When it comes to counterterrorism activities, it seems that we're made believe that the countries that are on the ground carrying out military operations to counter terrorism should therefore carry also a higher weight on the way in which they interpret the law. I don't agree with this proposition, and it would also imply that then it would force all of us to be engaged in those military activities to be able to have a voice and to have an opinion. I think that part of the problem indeed is silence, but there's a misconception on silence as well, because in this practice that I refer to specifically on the invocation of Article 51, The lack of reaction by many states has not been because of acquiescence, but a lack of visibility to this issue where the practice had not been seen or understood. And the third point that I would say with that on balance is that the work of academicians and writers matters too. And the biggest bulk of publications come from a certain group of countries and writers and researchers that are from either from the nationality of a certain group of countries or that have been formed in these countries. And therefore also, even from the point of view of doctrine, sometimes there's a feeling that there's an imbalance. And I fully agree on linking this point to something that Nicola mentioned, the need to have accountability. And the way to have accountability for those practices, for example, is also to give more visibility first and transparency to some of these things. There was another question just on working methods of the Sixth Committee regarding small states. Very little has been done. I mean, small symbolical things like there are no parallel meetings to make sure that delegations don't have to split in meetings of the Sixth Committee, or that we now have briefings from the Secretariat to level everyone up with the topics that we're addressing. But for sure, this is not enough, and we have to think more about working methods to improve that. Yeah, I think I would stop here. I have other comments with respect to what other panelists have said. I would just agree with Dida's point of the unfairness of the unwritten rule of the UN architecture and on who takes certain spots. He spoke about the Office of the Legal Advisor. I think Dida, the same thing has happened for the Deputy Legal Advisor that always has the same nationality. OCHA, the head of the Humanitarian Affairs Office, has always been of the same nationality. The head of the Department on Peacekeeping Operations has always been of the same nationality, these nationalities being of the P5. So yes, there is clearly an imbalance on the UN architecture. And I think part of the problem of why we haven't fixed it goes again back to the opacity in these methods where there are personal appointments. It's not an issue that is discussed openly with all member states, and it's very difficult to get somewhere there in the way. I'll stop here, Lila.
Thank you so much. And I think in respect to the silence, Madeline George, our ILW administrator, has just pointed out that we do have a panel on silence in international law and what it means when states are silent. And this question is, are they acquiescing or are they simply unaware? So Nicola, over to you now, and please feel free to take up any of the questions in the chat. People can't read the questions in the chat, so do read the question or just say you're responding to it if that's what you're doing. So thank you. Nicola, over to you.
Yeah, I will try, even though, reading the chat and and listening to the panel at the same time is an exercise which is not always easy, at least for me. I will try also maybe to respond to the question about transnational law. But I would like to make three comments in respect of what I heard. The first one is, we should also learn how to take advantage of crisis. Let me give you an example. I think one important development of the COVID is exactly what's happening today, which is, as you said, 1,500 delegates, 70 nations. International negotiations in the future will be hybrid. That's for sure. We will not go back to the great mess, even though Glasgow may seem to show otherwise. I think we need to take advantage of that in order indeed to give more voice to those who cannot travel, those who have less, space, to give them the space. We need to find ways, though, to provide a real voice to those, and I think the technology can help. The second observation is on what Dira said, and I was smiling when he was mentioning the General Council of the UN. He's absolutely right. And there are too many of those unwritten rules in all our international organizations. Why is it the World Bank and the IMF have these crazy unwritten rule that, you know, the World Bank is always to be headed by a US national, and the IMF is always to be headed by a European. What's the meaning? What's the purpose? What's the efficiency of that? And you know, in the OECD, there was also an unwritten rule that the General Counsel was French, and it lasted for 25 years. And since I was not the one breaking it, someone before me broke it. But you know, there are too many of those who are really hindering the progress. And the third point, I think the point that you again made on solidarity, I think it's a super important point. It's again, we need to understand that. I hope that everybody now understands that the world is not infinite, that the resources are not infinite, and that we need to share those in a better way, in a fair manner. Let me give you an example, you know, and also taking advantage of the fact that Pablo is Mexican. The United Nations Convention Against Corruption, the Merida Convention, has a Section 5 on asset recovery. The convention has been enforced since 2005. What progress have we really made since 2005 in this area? Virtually zero. Virtually zero. So, I mean, solidarity is also true. You know, in French, there is a saying, it's not enough to speak about love, we need tangible proof of love. And you know, it's not enough to have Section 5 if at the end of the day you don't operationalize it and you don't really making it a reality. So, so these are my 3 comments at this stage.
Thank you so much. That's really, really thoughtful. I would say on the technology, it cuts both ways, right? Because one of the things that I'm learning through my observation of the 6th committee, for example, is that if you're not able to actually go have a cup of coffee with somebody and have an off-the-record conversation, sometimes it's very difficult to make progress if it's all very formal Zoom meetings. And I have to apologize to everybody. I'm also getting Zoom bombed by my cat, who's asking us not to forget the other life on this planet, apparently. So we have some great questions in the chat. One goes to, gosh, I don't even know where to start. Let's try this one. It says, thank you to all. In 1965, a representative of a P5 member state, who I won't name, described his country as moving towards a bicameralism, a great compromise in which the Security Council became an upper house to the UN General Assembly. Did this effort succeed? Why or why not? And I think we heard some criticism of the council, both from Diri Tlade and from Pablo. So Diri, do you want to take that one up? And then Pablo, do you want to comment quickly? And then I have one here that's maybe more for Nicola.
Yeah. So actually, I mean, I did want to comment on that particular question. The answer would be, unfortunately, yes, right? So it has happened over time that you have these 2 main organs of the United Nations, and one of those organs has been very brave in terms of interpreting its powers very broadly, while the other one hasn't been that brave, right? So the UN General Assembly, for example, has taken very seriously the limitations imposed on it by the Charter, whereas the Council, so if you think about these 2 bodies, so when I speak to my students, I always say, if you think about the General Assembly, its great advantage is the breadth of its powers, right? In the sense that it has the mandate to deal with a whole lot of things, but the depth is not there in the sense that it doesn't have the power to make binding decisions. It's limited in terms of what it can do, but in terms of the subject matters, it's broad. Whereas the council, at least in terms of the text, it has a very narrow, so in terms of breadth, if you look at the text, it's supposed to have a very narrow mandate, but with respect to that very narrow mandate, it has deep powers. But over the years, the council has in fact interpreted its mandate very broadly, such that now it has very broad mandate, but also very deep powers. And so essentially it has become almost the upper house. I mean, if you think about things like the appointment of the Secretary General, right? So in terms of the charter, there's a particular process in which so the choice is to be made by the General Assembly on the recommendation of the Council. But the result is normally the practice has been that the Council gives one name. So essentially, it is the Council that makes that determination, right? Now, I know there's been some amendment of the process, but the result remains the same. That is, there's one name that goes to the General Assembly. So essentially, the General Assembly doesn't have a choice in terms. So yes, I mean, I certainly think that the Council has become sort of the upper body. In fact, there's one other even more important example of this in terms of the choice on new membership. It's supposed to be the General Assembly, right? So on the recommendation of the Council, but the manner in which the practice has evolved, without Council endorsement, the General Assembly can't even make the decision. So yeah, absolutely, I agree with that question. So with a point that was made there.
Thank you, Pablo.
Well, I mean, I understand the realpolitik of all of this, but I would strongly argue in favor of the General Assembly based on a couple of things. First of all, by mandate of the UN Charter, there's no hierarchy amongst principal organs of the United Nations. They're all at the same level, together with the ICJ, the ECOSOC even. So I think I'm unwilling and reluctant to accept that the Council should be just considered that is the superior body. It is not. And we're on the same floor in the same floor of the UN building at headquarters, and we should treat them the same way. What I think we should also think of and look at are the ways in which the General Assembly can be empowered. And I'm to counterbalance Dire's comments, I'll also give 3 examples of things where the General Assembly has been a driving force for issues. So I think the quintessential example of this is United for Peace and the United for Peace resolution. And the practice and the opinion of the legal counsel that remains is that if the council is not being seized or addressing an issue, the General Assembly can, and if it is paralyzed, actually, the General Assembly can step in and actually, through United for Peace, take decisive action, including military options, which were included in the 1950 resolution. And there have been extraordinary meetings convened by the General Assembly. We worked on one on Syria that led to the adoption of a resolution in the General Assembly to allow for humanitarian assistance, precisely based on the argument of the paralysis of the Council. I think the creation of the IIIM, the mechanism for investigations in Syria, that also came from the General Assembly, is a good example of how it can rise up to the expectation of accountability. I think the fact that it was the General Assembly, the first one who had a resolution on equal access to medicines and vaccines at the beginning of the pandemic, months before even the Security Council addressed this issue, is another example of that. I think tensions between those 2 bodies can be seen in the different language that is used, even in the counterterrorism realm, where there still is a reluctance from the General Assembly to endorse language that comes from Security Council resolutions and that do not find their way into the Global Counterterrorism Strategy Review, which is a resolution from the General Assembly, making the point that the General Assembly will not just endorse what 15 members have decided. And there's also a recent initiative from Liechtenstein to try to pass a resolution on, speaking again about this issue of accountability that Nicola mentioned, which I think is key, and also key what he said of following up on these commitments, to at least convene a debate of the General Assembly anytime a veto is exercised, so that can be addressed publicly in that other body. So to me, that is one of the exercises of reinforcement of the General Assembly, saying, you, Security Council, also have to be accountable to us. Because of a mandate of the Charter Committee, the Security Council acts on behalf of all of us. And therefore, the responsibility of accountability for me falls upon the council. And now being elected members, which is a huge privilege compared to the ones that are members just because they wrote their names into the charter. This reinforces this idea for us of we have to come back to the General Assembly and be accountable of what we're doing there to the members that elected us.
Thank you so much, Pablo. And maybe, Nicola, you'll have the last word. The very first question we had was, what can developed countries do to ensure more transparency, accountability, better participation? You've been with the OECD for a long time, and now you're in private practice. What's the job for the developed countries to do?
Well, I think Diri wanted to have a quick reaction to what Pablo said. So,
Diri, I see your hand is raised, but
yeah,
very quick. We only have 3 minutes.
Yeah, I will be quick, and I think I also didn't get the second round, so maybe this is just out of No, I mean, I think it's look, normatively, I agree with you, Pablo. But the reality, I think, is different. So if you think about the Uniting for Peace resolution, I mean, how many times has it really been invoked? And how many times has it been invoked for something meaningful in which the General Assembly can exercise, a real power? You gave the example of the first Syria resolution, and I think that was in 2014. That was not, as far as I can recall, a Uniting for Peace resolution. It was just the normal, right? So that was not a Uniting for Peace resolution. It was a resolution that simply, in which the GA did what it simply is permitted to do, which is to make recommendations and nothing more. So it still doesn't address the issue of, well, we are limited under the charter. We're going to go beyond that by doing something that the charter does not permit us. Like, for example, referring the situation somewhere or, right. So I think that resolution doesn't really address the question, I think.
Fair point. And Nicola,
so
you have to sum up now.
I will be very quick. Listen, for a long time, let's be very frank, for a long time, the developed countries have, basically, they are the ones who have set up international law, as we know today. And they have been basically acting about the principle of do what I say, don't do what I do. I think it is time to change this. And, it is incumbent on the developed countries to do so. It's also incumbent on the developing countries or with emerging countries to come at the table, with also a way of addressing the issues less, maybe again, less 70s and 80s. But I think on that, I'm rather optimistic. I see evolutions, and I see, for example, what the OECD has been managing to do in an international tax, having 140 jurisdictions at the table, including a number of developing countries, in an era which was not at all governed by international law, by the way, was pretty much either national law or at most bilateral laws. And this is only almost a counterexample that a new international law can still exist.
Thank you so much. And I think if the president were here, she might also say, some actual resource transfer, right? So more voluntary technical assistance funds and making it really possible for people from the developing world to fully participate in person as well as remotely with what is happening. Please, everybody, join me in a round of virtual applause for what was truly a spectacular panel. We just didn't have enough time to get to everything that we needed to, and hopefully you'll be able to learn or speak to panelists and some of the other panels during the weekend. And I know that this panel has given me a lot of food for thought as we begin International Law Weekend 2021, Reinvesting in International Law. So thank you so much, Diri. Thank you, Nicola. Thank you, Pablo. And thank you, Nazit. And we're just delighted to have been able to host you and have the benefit of your expertise to kick off our weekend. So I think we are at exactly the hour, 3:30, and there is now a short break resolution 71-130. There's now a short break for 15 minutes. We'll close this session. And for those of you attending the weekend, you know you have to go back to the homepage and then you can choose one of the 4 panels that will begin precisely at 3:45. Thank you, everybody. The obligatory Zoom wave. Thank you.
Bye.